Good morning, Your Honor.
Good morning. We have both counsel present. Mr. Johnson, I understand you represent the appellant. Is that correct?
That is correct, Your Honor.
Did you wish to reserve any time for rebuttal?
5 minutes, please, Your Honor.
Okay, got it noted. And you may proceed, counsel.
Thank you, Your Honor. This is a single issue before the case that has a number of sub-issues. We're here asking the court to reverse the trial court's ruling denying Touchpoint's motion to dismiss or transfer venue from Pinellas County to Pasco County. I'd like to start with the proposition that we do not have a mandatory venue selection in this particular case. We have a mandatory jurisdiction selection in the contract in this case of 9.9.
Mr. Johnson, I had a real hard time parsing what appears to me to be a scrivener's error in the APA. You all have sort of each tried to make a substantive argument like that was an intentional drafting, but I don't follow that. It doesn't make any sense to me. It just looks like it's a drafting error, and it would appear to suggest that wherever the plaintiff brought suit in Florida was going to be where it was going to be, and the defendant was waiving any right to complain about it. And you have made a real strenuous effort to try to convince us that appears to be a drafting error somehow has some substantive impact. You want to walk me through that?
Sure, Your Honor. We start off with section 9.9 initially being about jurisdiction. If we look at the language of 9.9, it talks about the buyer, seller, and the shareholders hereby agree and consent to be subject to the exclusive jurisdiction of a United States District Court for Florida. And then it goes on to say, if jurisdiction is not present in federal court, then buyer, seller, and the shareholders hereby agree and consent to the exclusive jurisdiction of any state court of Florida. And I'm not going to argue with this court that doesn't contain a scrivener's error. I think it does.
Right.
I think it's a...
So the shouldn't be there, right?
Or
the any shouldn't be there. You get one or the other, I guess, right?
Okay. Appears that counsel is electronically frozen. Can we bring him back?
I thought he'd gotten quiet.
Yeah.
Is this in keeping with where we were teleporting people earlier? Now we're using the Star Wars freezing methods?
Yeah, I think we moved to the modern technology. Star Wars been zapped.
Mr. Johnson, can you turn your camera on and off? Sir, it looks like we lost him totally. We'll have a momentary pause until he can re-log back in.
Okay, as they would have it, I have stopped his time clock. It is frozen at 2 minutes and 36 seconds.
Yes, sir. Sir, he's going to call in. So once we get him called in, we'll transfer the number in and you'll see a number on the screen with his name, but we
Okay.
won't have video.
All right, thank you.
Yes, sir.
I would ask the panel members if they would take a look at email message that was sent to you. Actually, it's on the Teams. I apologize.
Sir, he had joined and then he hung up the phone. Please stand by. There he is, sir.
Okay, I will ask the proverbial question, where?
Mr. Johnson, you're back.
Are you?
He needs
Mr.
to
Johnson,
unmute his
you're on
phone.
mute.
You may need to unmute, Mr. Johnson.
Should
I
be
hit too
good
many
now.
buttons. I
Okay, we can hear
apologize.
you.
Our Wi-Fi has gone down completely in our office.
Oh, dear. Well, in light of what's happened, so I can make sure we do it right, why don't we start from the top? And I'll let you start again.
Thank you, Your Honor. I will go directly to Your Honor's point with respect to our issue that there is no mandatory venue clause in this case. When we look at section 9.9 of the APA, it speaks to issues regarding jurisdiction. It starts with that the parties agree that they're going to be subject to the exclusive jurisdiction of the United States District Court for Florida. And then if jurisdiction is not present in federal court, then buyer, seller, and the shareholders agree and consent to the exclusive jurisdiction of any state court of Florida. Well, of course, jurisdiction runs statewide. It is not a venue issue. It is a statewide jurisdictional issue. The issue that Your Honor broached, that the Scrivener's era of any was involved, I do believe that that's a Scrivener's error, but I think that it can be read in conjunction with the remaining language concerning waiver that gives the contract a reasonable meaning, that the parties agree that they won't object to venue for purposes of trying to take the case outside of Florida, which would be the case if the matter were initially filed in federal court and one of the parties, my client in particular, which is a Delaware corporation, attempted to transfer venue from a Florida federal court to a Delaware federal court, for example. The waiver such that the parties would be free to sue anywhere in the state of Florida, and we've made this point in our brief, based on the matter being in state court, frankly, would create a nonsensical situation with respect to the party's intent, because as we've said in the briefs, there's no connection to this case in Monroe County or Escambia County or any of those locations, which, given the reading that the appellee ProMedica would ask the court to use, would be a logical outcome.
But Mr. Johnson, this is Judge Stargell. I don't know you can see us,
Yes,
or you're
sir.
just listening. But it was good to see your face momentarily for the first time in many, many years. So to hear your voice. But are you suggesting that it would be nonsensical if the parties intended to allow someone to have venue anywhere in the state? If they wanted to contract for Monroe County or Duval County or Escambia County, they could do that, could they not?
If they chose a specific county, certainly they could. And
Why couldn't they choose anywhere in the state?
Well, and I was
Blanket.
going to address that. I think that if they were saying that they were going to allow suit to be brought anywhere in the state of Florida, in the Florida state courts, as opposed to having a waiver of objection, then I don't think that we could make the argument that we are, because there would be clear intention by the parties that that's what they meant. But what we have here in section 9.9 is a section that mixes jurisdiction and venue, federal and state, in ways that candidly don't make a lot of sense, because the federal system has different issues than the state system, most notably in this case, the ability to transfer a case out of Florida to another state court, or excuse me, another federal court in another state. But we don't have that here.
And then that you're correct on, that the venue could be challenged. Could you shift then to the substantial inconvenience, particularly the fact that, Pinellas and Pasco, not only are they connected counties, they're one in the same circuit. How is this a substantial inconvenience?
Well, I think that it is a substantial inconvenience if we are looking at the distance and the issue of having to bring witnesses both for depositions and for trial, and whatever evidentiary hearings might occur within Pasco County to Pinellas County. The appellee talked about this in the context of miles. Those of us who have driven US 19 across the Courtney Campbell and across the Howard Franklin know how unpredictable all of that can be, and how time consuming all of that can be. But there's a more basic point before we even get to the inconvenience issue, and that is the issue of where is venue proper in the first place. And that was part of the motion below before the trial court, that venue was not proper in the first place in Pinellas County, because the venue statute provides that this case should have been brought where the cause of action accrued or where the defendant is located. And our client, and we have an affidavit that's unrebutted on this point, is located in Pasco County. And therefore, Pasco County is the initial appropriate place for the suit to have been brought.
But this is a dispute over this $3 million or so payment pursuant to this APA, and the plaintiff's place of business is Pinellas County, and arguably that would be where that $3 million is due, I would think, because they're saying you owe. Again, we have to sort of take the allegations of the complaint as true for these purposes, and they say it was due and owing in Pinellas County. Your failure to pay it, arguably the breach is in Pinellas County because, it was breached because it wasn't received by them at their home office. So how do you respond to that?
I assume this is Judge Morris.
Yeah, I'm sorry, it is, Mr. Johnson. Forgive me. I forgot you can't see us.
No, thank you. I thought I recognized the voice. Your Honor, I think that to address that question, you have to look at the court's prior rulings in the Coslow and Knowles cases. And basically what it boils down to is, are we dealing with a situation where we have a bill that's rendered for $3 million and it's due to be paid at a time certain, and it's not paid? That's not what we have here. We have an APA that requires performance, and the payment that the plaintiff seeks is based upon the performance and the levels that my client reached in terms of generating revenues. And that is not a liquidated sum at the time that this contract was created. And frankly, when you look at the amended complaint, it's not a $3 million payment that they're seeking. What they're saying is that in a single count, that they believe that they're owed $3 million plus, because they've alleged that they're owed the $3 million plus additional monies because they have alleged that my client did not properly operate the business during this period of time described by the APA. So this is not a situation in which the plaintiff has brought a case in which there is a liquidated amount that is due that would create this debtor-creditor issue for purposes of venue. And that's exactly what the Coslow and the Knowles cases addressed. And then there's also, we've cited the third DCA in PDM Bridge Corp versus JC Industrial Manufacturing, which again, if we've got amounts that are in dispute, the place of payment is not the place that is the situs for venue. So under these facts, we don't have Pinellas County, as the plaintiffs have pled it, as the appropriate location for payment of a jurisdictional, or excuse me, a liquidated amount, because it's not a liquidated amount, either in the basis of how the $3 million is arrived at, or what the plaintiff alleges it is seeking in the amended complaint.
Mr. Johnson, this is
finally-
Judge Casanway, but if I could ask you a question. The sums being sued for in this cause of action, are they sums that meet the definition of purchase price in the contract, or is that at another location of the contract?
They are sums that are part of the purchase price, Your Honor, but they are sums that are determined based upon the party's performance over the period of time between the closing of the APA and the time when payment would be made.
The reason I inquire is that under 2.4b, it says all payments shall be paid to a bank account designated by the seller in writing to the buyer. I'm wondering if that provision trumps the general rule about debtor relationship and the parties have contracted to where the payment is due.
Your Honor, in all candor, I have to tell you that there is, to my knowledge, and I believe Ms. Lopez will confirm this, there is, to my knowledge, no specific reference to such a location anywhere within the record before the Court on Appeal.
Thank you.
The last point that I would make is that we did challenge through Mr. McPherson's affidavit in our motion the existence of venue initially with respect to the fact that we stated Mr. McPherson's affidavit that Touchpoint is found in Pasco County. There's no reference to Touchpoint being found anywhere else. And we know that there was no counter affidavit to Touchpoint's affidavit on this point. And then Mr. McPherson also discusses that the vast majority of the witnesses and the documents are in Pasco County. And again, there is no contradictory affidavit on that point in the record. Instead, the plaintiff relied on its pleading in opposing the motion to dismiss or transfer. So for those reasons, we believe that Mr. McPherson's affidavit has to be taken as unrebutted, undisputed, and there is no reference anywhere in the amended complaint by ProMedica that there's any reason for venue in Pinellas County other than this debtor-creditor relationship, which we don't believe exists, or the argument that there is a general waiver that these parties can sue anywhere in the state of Florida, which we do not believe is intended by the agreement. We don't believe that it makes logical sense, and we've cited the Hester case for the proposition of construction of the contract in a manner in which would make logical sense. And frankly, we believe that there is a patent ambiguity on the face of that agreement in this regard, which would require the court to give that provision no impact and relate back to the general venue rules, which under these circumstances and the record before the court would place this case in Pasco County. I'd like to close on one issue with respect to the argument that, well, it's, Pasco and Pinellas are in the same judicial circuit, and therefore we should not treat the county of choice as we might treat it if we were talking about, say, Hillsborough or Pinellas. But that's not what the venue statute says.
Ms. Johnson, you're at 15, just so you know.
Thank you, Your Honor. The venue statute says very clearly that it is based upon counties where lawsuits should be brought. And in this case, we respectfully submit to the court that the appropriate county for this lawsuit was Pasco County. Thank you, Your Honor.
Thank you, counsel. Attorney Lopez, you may proceed.
Thank you, Your Honor. Good morning. May it please the court. My name is Lindsay Lopez, and I represent ProMedica. And in
Ms.
this
Lopez,
case,
one of the things that I was curious about is you didn't file any affidavit in opposition to their motion, and there was no evidentiary hearing of any type. Is that a problem?
no, Your Honor. The case law is pretty clear. If you look at the residential mortgage versus Kiesling case, and all of the cases really, I can go into them in more detail, that if they file an affidavit that controverts the basis for our venue claim, then that shifts the burden to us to rebut that and to defend against this. In our case, our complaint, or the amended complaint, sets forth two bases for venue. One is the APA and the section 9.9 of the APA, which we've gone through in detail. And that we can just...
We have, but the APA talks about jurisdiction, doesn't talk about venue.
It talks about both, Your Honor. It talks about, it kind of has four parts. First it says, well, it has five, I guess. First it says federal court. Then it says exclusive jurisdiction is in any state court of Florida. And then it says that once you're in that, once you get to that jurisdiction element, that the parties waive any objection that venue is not proper in any such court, or that venue is inconvenient in any such court, or that there's no personal jurisdiction.
Okay.
So it's tied together in that way. And so we filed our complaint. We alleged that venue was proper under the APA section 9.9 and also under this debtor-creditor relationship. If you look at Mr. McPherson's affidavit, it doesn't controvert any of that. It really deals with a forum nonconvenience issue, and that's not a disputed issue that the court needed to resolve because it's been waived in the APA. So there was no reason for the court to resolve that factual dispute, because any arguments about the convenience of the parties just aren't relevant. And even if you take everything in Mr. McPherson's affidavit as true, It's not enough. This is the exact issue that this court dealt with in the Florida Health Sciences case that we cited in our brief. And in that case, the defendant made the same argument, which is that the trial court erred by not granting our motion to transfer venue because we're the only ones who put forward any sworn evidence. And the court looked at it and they looked at the affidavit that was filed and they said, it's not enough. If you look at that affidavit, it doesn't reach the standard that's necessary for forum nonconvenience. It doesn't talk about who the witnesses are. It doesn't talk about it doesn't identify the potential witnesses. It doesn't describe their anticipated testimony, and it doesn't describe the relevance. And based on the lack of specificity in the affidavit, the trial court properly denied the motion. That's exactly what we're dealing with here in the affidavit from Mr. McPherson. It says that there are witnesses that are going to be in Pasco County. It doesn't say who they are, what their testimony is, or why it's going to be so difficult, why it will be a substantial inconvenience for them to travel to testify in Pinellas County, because the standard isn't that it would be more convenient, it's that it would be a substantial inconvenience, even assuming we get to the issue of convenience, even assuming that that issue has not been expressly waived by the APA. And so because the affidavit didn't controvert our basis for venue, there was no need for additional evidence to rebut that. Even if you take everything he says is true, it doesn't change the venue analysis in this case, Your Honor. And we've talked a lot about what the APA says. We just walked through the allegations there. The only reasonable interpretation of the APA is that it should be that the jurisdiction and venue are proper in any state court in the state of Florida. And Mr. Johnson has argued that that's an unreasonable, that interpreting it in that way would be unreasonable because it could be in Escambia County, it could be in any other county, but there's nothing inherently unreasonable about that. That's what the parties contracted to. It's certainly no more unreasonable than, for example, the Manrique case, which involved a case that the court would have otherwise had jurisdiction over in Florida, but there was a venue selection clause that said it needed to be tried in the Netherlands. Similarly, the Corsac case, where the court would have otherwise been able to litigate it in Florida based on the forum selection clause, the mandatory forum for that was Spain. And in that case, the defendant argued Spain, that the court should not enforce the selection clause in that instance because it would take 6 or 7 years longer for the case to resolve in Spain. And the court said it doesn't matter, that when you're looking at whether a forum selection clause is unjust or unreasonable, it has to be so unjust or unreasonable to effectively deprive you of your day in court. And even a case that will take 6 to 7 years longer to play out across the ocean in Spain is not sufficient. If you look through our briefing, I think you'll see that the parties actually agree on many of the important legal, factual issues and legal principles in this case. And in many cases, we've cited the exact same cases. So we agree that we entered into the asset purchase agreement and that it includes section 9.9. We agree that as the plaintiff, ProMedica had the right to choose between appropriate venues. We agree that ProMedica filed suit in Pinellas County and that the amended complaint identifies section 9.9 as one of the bases for venue. We agree, and this one is a pretty significant agreement. We both cited the Bombardier case that says that mandatory forum selection clauses should be enforced unless they have been procured by fraud. They're the result of one party's overwhelming bargaining power, or the sole basis for jurisdiction is the sole basis for jurisdiction in the court is the forum selection clause. And nothing in Mr. McPherson's affidavit, there's no evidence ever that's been submitted anywhere that any of those situations apply with respect to section 9.9. And we also agree that a contract should be interpreted in a manner that gives meaning to all the provisions of the contract, that you should never interpret a contract to read out or render one provision meaningless. And in this case, we're looking at the same language. They're asking the court to interpret section 9.9 to read out the word any, just say this should be in the state court of Florida. And that's not a reasonable interpretation of the contract. There's nothing about the inclusion of the word the that changes.
Well, let's take that argument though. What if you went with the? Doesn't that really kind of mean you can bring it anywhere? I mean, I mean, how else would you interpret that? There is no state court of Florida.
Well,
Right. Yeah, I mean, any is better, but does awkward, but it doesn't get you to the same place.
I think so. I think you're yes, it needs to be brought in the state court of Florida. And if you look at the provisions that fall under it, it's got to be any state court of Florida because, for example, Mr. Johnson said, well, we're just saying that as opposed to Delaware, it needs to be in Florida. But if you're looking at a case that should have been brought in Delaware, and based on this forum selection clause, you find yourself in Florida, then how can you ever pick which venue it should be? Because he's saying there needs to be an independent basis for venue. And it's just not a reasonable interpretation of the entire structure of that provision. He talked a little bit about the where the cause of action accrued. That's an alternative reason that we've said that venue is proper in Pinellas County is that the payment was due in Pinellas County. I will, Judge Casanueva, agree with Mr. Johnson that there's nothing in the record that talks specifically about the bank account that's referenced in section 2.4. But that brings us back to the general proposition that the payment should be made at ProMedica's place of business in Pinellas County. In this case, we are dealing with a contract that was for the payment of a purchase price, a payment of a sum of money, and that sum of money is liquidated. If you look at section 2.6, it sets forth very specific amounts. They're tied to revenue, but the damage amounts are liquidated. If the revenue is below $10 million, the incentive payment is $2 million. If it's between more than 10 million, but less than 11 million, then it's $3 million. And then if it's higher than 11 million, it's $4 million. There's no additional work. Once we prove the breach, there's no additional work that the court will need to do to determine the amount of damages. And so the amount of damages can be proved just by looking at the allegations of the complaint and by looking at section 2.6. And there was also an issue raised about whether or not there needed to be an evidentiary hearing in this matter. I would just submit that this is the same as the issue related to whether there needed to be an affidavit, which is there were no factual issues that needed to be resolved. But also importantly, this isn't an issue that's been preserved for review. There's no transcript from this hearing. In order to object to the manner in which the hearing was conducted, there would have needed to be a timely objection. That's the NRD Investments case that we cited that relates to whether or not there needed to be an evidentiary hearing for a temporary injunction. And the court says if you want to preserve that issue for appeal, you need to make a timely objection. Without a transcript, there's no way the court can determine whether or not there's been a timely objection. And so that's not an issue that's been preserved for review. So unless the panel has any other questions, we would submit that the court properly denied the motion to transfer venue, and we would ask you to affirm.
Thank you, counsel. Can we stop the clock here? Clear. Mr. Johnson, you have 4.5 minutes for rebuttal.
Thank you, Your Honor. Can you hear me?
Yes, sir.
Okay, perfect. I'd like to start near the end of Ms. Lopez's argument. With respect to the argument that once the breach occurred, it was just a matter of writing a check that the damages were liquidated. I'd ask the court to look at paragraph 13B of the amended complaint, which says that Touchpoint breached section 2.7A because it did not conduct the business in all material respects consistent with the manner in which the business was conducted by ProMedica prior to the closing date. And it lists a line of actions that include failure to act in a commercially reasonable manner, to maximize the incentive payment, et cetera, et cetera. That is anything but the pleading of a liquidated amount. So we respectfully disagree with the concept that this is a straight up debtor-creditor relationship. that would justify setting venue where the payment would be due. The next point I'd like to draw the court's attention to is each of the cases with respect to a mandatory venue provision that have been cited by the parties actually had a mandatory venue provision that said the lawsuit will take place in Corsac, Madrid. And of course, in Corsac, there was a Spanish company involved. And that's why venue made sense for those parties in Madrid. There is not a single case that the parties have cited, and I'm confident if it had been out there, we would have cited it to you on one side or the other, that addresses a venue provision that says you can sue anywhere in the state of Florida, and that constitutes a mandatory venue provision based upon wherever the plaintiff chooses to sue. It doesn't exist, and it doesn't make sense because, as the court noted, there is no unitary the court of Florida. What does make sense is that in some respects, there is a single court in federal court. There's a single jurisdiction, or excuse me, district court in Puerto Rico or Delaware. And having the parties waive any claim that a suit could be brought in a single district court makes some sense. But frankly, if we look at this contract, there are a number of things that frankly just aren't covered. And if the reference to incentive payments in section 2.6 says that if the parties have a dispute over the incentive payments, that you look to the provisions of 2.8 C, D, and E as to how you go about resolving them. Unfortunately, there is no 2.8 C, D, and E. So what we have here is a bit of a square peg being shoved into a round hole. And we respectfully submit to the court that construing this agreement in a way that it is mandatory that a plaintiff on either side of this case could assert venue in any county in the state, regardless of the county's connection to the parties or the business, is not an appropriate result and not the result that this court should come to. We respectfully request that the court reverse the trial court's ruling and remand with instructions that the case be transferred to to Pasco County, excuse me. Unless there are other questions, I appreciate the court's time and attention and cooperation in my technical misery.
Could have
Thank
been
you,
me,
counsel.
Mr. Johnson. Technology can frustrate all of us.
Thank you both. We'll let
But
you
without it, we
transition.
wouldn't be having court at all right now. So.
That's true.
That's right.
That's exactly right.
Thank you both.
Thank
And
you.
we'll-